72 hours and 11 minutes. That is how long it took from the moment Pam Bondi received Kash Patel's hospital blood alcohol test results showing 0.26 BAC, more than 3 times the legal limit, to the moment she walked into the acting Deputy Attorney General's office, slammed the medical report on his desk, and said 6 words that ended the debate. "Fire him today, or I go public." Watch what happens when Bondi gets the hospital fax at 3:47 p.m. on a Tuesday afternoon showing that Patel, who had attended a classified briefing about Iranian nuclear capabilities that morning, had a blood alcohol level high enough to render most people unconscious. Watch her make the first of 11 phone calls demanding Patel's immediate termination. Watch her face resistance from officials who claim they need time to review, need to consult counsel, need to follow procedure. And watch 72 hours of the most relentless pressure campaign ever conducted by an Attorney General culminate in Patel's termination, security clearance revocation, and criminal referral for lying on federal forms. You need to see this from the beginning because what happened in those 72 hours is not just about one firing. It is about what happens when medical proof of unfitness meets institutional reluctance to act, and one person refuses to accept that reluctance as an answer. Let me set the scene for you. DOJ Headquarters, Attorney General's Office. Tuesday, 3:47 p.m., Bondi at her desk reviewing sentencing guidelines when her assistant walks in with a fax that just came through on the secure line from Walter Reed Medical Center. The cover sheet is marked Urgent, Medical Records Request Response. Bondi had requested Patel's medical records 4 days earlier after receiving witness reports that he appeared impaired during the Iranian briefing. The hospital resisted citing HIPAA. Bondi got a federal subpoena. The records arrived 20 minutes ago. Bondi's assistant hands her the file. She opens it. The first page is a blood test result from March 8, 2024, 11:30 a.m., 6 hours after the Iranian briefing ended. Patient name, Kash Patel. Test ordered, comprehensive metabolic panel, including blood alcohol content. Result, BAC 0.26. Bondi stares at the number, 0.26. Legal limit for driving is 0.08. Patel's level was more than 3 times that. 6 hours after the briefing, which means during the briefing his BAC was likely over 0.30. Bondi picks up her phone. She calls the acting Deputy Attorney General, Michael Torres. He answers on the second ring. "Michael, I need you in my office immediately." "I'm in a meeting with—" "End the meeting, now." Torres arrives 8 minutes later. Bondi hands him the medical report without saying a word. He reads it. His face goes pale. "Where did you get this?" "Federal subpoena to Walter Reed. It's authenticated. Patel's blood alcohol was 0.266 hours after attending a classified briefing. Do you understand what that means?" Torres sits down. "It means he was dangerously intoxicated. It means he was drunk during a briefing about Iranian nuclear capabilities and then drove himself to a hospital where they documented his BAC. We have proof, medical proof. He needs to be terminated immediately. We need to follow termination procedures. The procedure is simple. Employee shows up drunk. Employee gets fired. What procedure are you talking about? We need to give him opportunity to respond." "Respond to what? A blood test? You can't argue with a blood test?" "He has due process rights." Bondi leans forward. "He waived those rights when he showed up drunk to a briefing where he learned about nuclear weapons programs. Fire him." "I need to consult with counsel." "Then consult, but I want him suspended without pay within the hour and terminated within 24 hours. Torres takes the report. "I'll start the process." "Don't start the process. Complete the process. Today." If you have made it this far and this matters to you, subscribe now and hit the bell, because what comes next is 72 hours of Bondi discovering that institutional inertia is stronger than medical evidence and deciding to destroy that inertia with brute force. Torres leaves at 4:23 p.m. At 5:15 p.m., he calls Bondi. We have a problem. What problem? Patel's attorney is claiming the blood test was obtained illegally. It was obtained with a federal subpoena. He's claiming the subpoena violated doctor-patient privilege. There is no privilege when the patient is a government employee suspected of compromising national security. The subpoena is valid. His attorney is threatening to sue. Let him sue. Fire Patel. Legal counsel is recommending we wait until the lawsuit threat is resolved. Legal counsel works for me. I'm recommending we fire someone who was drunk during a classified briefing. Which recommendation sounds more important? I understand, but no buts. Suspend him. Now. Tonight. I want his badge, his credentials, and his access revoked before he leaves. The building today. He's not in the building. He went home after the briefing. Then send security to his house. Get his badge. Suspend him. Do it now. At 6:30 p.m., Torres calls back. Security went to his house. He refused to surrender his credentials. Then file charges for failure to return government property. That seems aggressive. Aggressive is showing up drunk to a nuclear briefing. This is called consequence. File the charges. I need approval from... You have my approval. I am the Attorney General. File the charges. At 8:45 p.m., Bondi receives an email from the General Counsel's office. Subject, Patel termination. Legal review required. The email outlines a 14-day review process, including witness interviews, procedural hearings, and appeals procedures. Bondi responds in all caps. He was drunk, 0.26 BAC. Fire him tomorrow or explain why not. The General Counsel responds 20 minutes later. We recommend following established protocols to avoid wrongful termination litigation. Bondi calls him. This is Pam Bondi. Explain to me how firing someone for being drunk at work is wrongful termination. If we don't follow procedure, he can claim we violated his rights. His rights don't include being drunk during classified briefings. I understand your concern, but do you? Because I have a medical report showing 0.26 BAC and you have a 14-day review process. One of those things protects national security. The other protects someone who was too drunk to remember nuclear secrets. Which one do you think matters more? Both matter. Then make them both happen. Review him, but suspend him first. Today. Right now. I'll consult with the Deputy AG. I just talked to the Deputy AG. He's waiting for your approval. Give it. At 11:30 p.m., Bondi receives a text from Torres. Suspension approved, effective immediately. Badge and credentials surrendered. Termination hearing scheduled for next week. Drop a comment right now if you think 1 week is too long, because Bondi is about to make that exact argument for the next 60 hours straight. Wednesday morning, 7 a.m., Bondi is back in her office. She calls a meeting with Torres, General Counsel, and Office of Professional Responsibility. The meeting starts at 8 a.m. Bondi opens with one question. Why is the termination hearing scheduled for next week? Torres answers, standard procedure is to provide 5 business days' notice. Standard procedure is for standard violations. This is not standard. This is a national security breach caused by intoxication. We fire him today. General Counsel interrupts. We need time to prepare the termination package, interview witnesses, and... Bondi cuts him off. Interview witnesses. We have a blood test. It's medical proof. What witnesses do we need? We need to establish pattern of behavior, document prior warnings. He was hospitalized 4 times for alcohol. That's the pattern. He lied on his security clearance forms about alcohol treatment. That's the prior warning. What else do you need? We need to ensure he has opportunity to contest the evidence. He can contest a blood test in federal court after he's fired. Right now, he's suspended with access to classified information revoked, which means he knows what's in those files, and we can't monitor him. Every day we wait is a day he could compromise sources. OPR Director speaks. Attorney General, I understand the urgency, but wrongful termination lawsuits are expensive and... So is a compromised nuclear intelligence operation. Pick your expense. The meeting ends at 9:15 a.m. No decision. Bondi calls Torres back at 11 a.m. What's the status? Legal is still reviewing. Legal has been reviewing for 18 hours. What are they reviewing? The termination package. It's one sentence. Employee was intoxicated during classified briefing. Blood alcohol 0.26. Termination effective immediately. What takes 18 hours to review? They want to ensure we're on solid legal ground. We're on medical ground. 0.26 BAC. That's not legal opinion. That's chemistry. I hear you, but stop saying but. Fire him. I will push legal to expedite. Don't push. Order. You're the deputy AG. Give the order. At 2 p.m., Bondi receives another email, this time from a different attorney in General Counsel's office. The email includes case law citations about wrongful termination, due process requirements, and appellate court decisions. Bondi responds, I don't need case law, I need termination. Today. At 4:30 p.m., Torres calls. We have another problem. Bondi closes her eyes. What now? Patel's attorney filed an injunction seeking to block any termination until after a full administrative hearing. On what grounds? Violation of due process? He got a suspension notice, opportunity to respond, and access to counsel. That's due process. Deny the injunction. It's filed in federal court. We can't deny it. A judge has to rule. Which judge? Judge Alan Kopel, District Court. When does he rule? Hearing is tomorrow at 10 a.m. Then we wait until tomorrow and fire him the minute the injunction is denied. If the injunction is denied, it will be denied. He was drunk at work. No judge is going to protect that. Subscribe now, because what happens at that hearing is the moment Bondi realizes this is not about law anymore, it is about protecting Patel. And she decides to burn down that protection. Thursday, 10 a.m., Bondi attends the injunction hearing personally. She rarely attends district court hearings, but this one is different. She sits in the gallery. Patel's attorney, Martin Shaw, argues for 20 minutes about due process, procedural fairness, and the need for a full evidentiary hearing before termination. DOJ attorney Lisa Chen responds with 8 minutes about national security, intoxication on duty, and medical evidence. Judge Kopel asks one question. Does the government have medical proof of intoxication? Chen answers, Yes, Your Honor. Blood alcohol content of 0.26, documented 6 hours after a classified briefing. Kopel looks at Shaw. Your response? Shaw. The test was improperly obtained. Kopel. Was it obtained with a warrant or subpoena? Chen. Federal subpoena, Your Honor. Kopel. Then it was properly obtained. Injunction, deny. Ed. DOJ may proceed with termination. The hearing ends. Bondi leaves immediately. She goes directly to Torres's office. He's on the phone. She waits. He hangs up. Did you hear? I was there. The injunction is denied. Fire him, now. I'll draft the termination order. Don't draft. Sign. I had legal prepare the order yesterday. It's on your desk. Sign it. Torres looks at his desk. The order is there. 1 page. Employee name, Kash Patel. Reason, intoxication on duty, 0.26 BAC during classified briefing, violation of security protocols. Effective date, immediately upon signature. Torres picks up a pen. He hesitates. This is career-ending for him. Being drunk at a nuclear briefing should be career-ending. Sign it. What if we're wrong? We have a blood test. How can we be wrong? What if there's context we don't know? Bondi leans over the desk. Michael, I have spent 72 hours fighting to fire someone who was dangerously intoxicated during a briefing about weapons that could kill millions of people. I have medical proof, I have legal authority, and I have had enough of context, procedure, and hesitation. Sign the order or I will find someone who will. Torres signs. The timestamp reads 11:47 a.m., Thursday, March 14, 2024, 72 hours and 11 minutes after Bondi received the blood test results. Torres hands her the signed order. What happens now? Now you revoke his clearance permanently. Now you refer him to DOJ Inspector General for criminal investigation of lying on SF-86 forms. Now you send this order to every federal agency so he can never work in government again. Anything else? Yes, you send him a certified letter informing him of termination and advising him that any attempt to access classified information after termination will result in immediate arrest. Torres nods. I'll handle it. Bondi walks out. At 1 p.m., Patel receives the termination notice via certified mail and email. At 2:30 p.m., his attorney calls a press conference claiming political persecution. At 4 p.m., Bondi releases a statement. Mr. Patel was terminated for intoxication on duty. His blood alcohol content was 0.26 during a classified national security briefing. This is not political. This is consequence. At 6 p.m., 3 news organizations obtained the blood test results through FOIA. By midnight, every major network has reported the 0.26 BAC number. Patel has not appeared publicly since. His attorney is threatening lawsuits that will go nowhere. And Bondi's 72-hour pressure campaign is now a case study in how one person with authority can force accountability when institutions resist. The test was positive. The termination is final. And 72 hours of resistance collapsed because Bondi refused to accept any answer except the right one. Subscribe now. Share everywhere. Because when medical proof shows someone is unfit and leadership hesitates, it takes someone willing to fight for 72 straight hours to make consequence happen. Bondi fought, Patel lost, and the system learned that blood tests matter more than politics.